House to Home, presented by RE/MAX Diamond Realty and Security Title.
All right, everybody, Hafaday, Jason Salas here, and I love being out in our island community, experiencing new things, meeting new people, and checking out new places. And Gina and Liz from RE/MAX Diamond Realty, we are in an amazing venue today.
Yeah, take a look around.
Yeah.
Yes.
This is Security Title in Mooning. You've probably seen the building a million times, but it is amazing in here. We're going to show you a little bit about it. And ladies, we're going to talk to our friend Kim Anderson about
Title, how it's vested, and the process.
All right, a very important topic so that you can get the home of your dreams. Let's go walk over and interview Kim right now.
So Kim, we talk about vesting title. You know, we can't give the advice because we're not attorneys. You are the escrow officer. You can explain to the community about how is title vested and what's involved, what's the process?
Well, you know, every family has their own idiosyncrasies, and we, no matter how much we get to know them, we don't know what's going on in a family's situation. So what we generally do is we show people like a checklist and a worksheet, and we'll say, what of these seems to fit your needs? And if they have any questions, we would refer them to their attorney. But basically, title is vested, ownership is vested. If it's not in like a corporation or an LLC or a trust, if it's owned by actual people, human beings, there are a couple of key ways of vesting title. First of all would be like sole and separate property, or that's also called tenancy and severalty. It's by one person.
So for example, if I own property and it was just my Liz Duenas sole and separate property, how does that affect my husband?
Even though a property is held as sole and separate property, there's the assumption on Guam, because it's a community property jurisdiction, that the spouse may have an interest. So for that reason, if you own a property as your sole and separate property, we would ask your spouse to sign a spousal consent if you were to sell or mortgage the property.
So that's why whenever we sell property that's referenced as sole and separate property, the spouse has to sign off on it.
It's an abundance of caution.
Okay.
And because we don't know if the nature was changed. Now, if you're not married, if you're an unmarried person, that's a very common way of acquiring title, as sole and separate
property.
And if you're a divorced person, you're also unmarried, so you can acquire property as sole and separate.
But the moment you get married, it complicates it a bit. So there's got to be a waiver from the spouse.
Spousal consent.
Spousal
or a waiver,
consent,
yeah.
if I sell it.
The other thing that's kind of interesting is if someone is separated, but not, and you can even have a legal separation. If they're separated but not divorced, they're still considered married.
Yeah, so any real estate transaction, if a person is separated, we've got to find the other party to clear off and sign off on the sale.
It's an abundance of caution.
Okay,
mostly.
got it.
Yeah.
Got it.
So that's talking about sole and separate property. We also have, there's two other ways of owning property with other people that are not necessarily your spouse, not necessarily community property. One is tenants in common, and the other one is joint tenants with rights of survivorship. So as a tenants in common, if you and I own a property as tenants in common, we each own it 50-50. So if I pass away, then you own 50% with my heirs.
I see.
And if you pass away, your heirs own it with my heirs, each 50-50.
50-50.
Yeah.
Right. Okay.
There's a joint, that's a tenants in common. There's also a joint tenants with rights of survivorship. And if you and I and Gina and Jason, all four own the property as joint tenants with rights of survivorship, basically we each own 1/4.
Right.
And we'll kill off Jason first.
Then the
So
remaining
when he
three
passes away, Gina, you and me each own a
own the
third.
property, right?
And if I pass away, you and Gina each own a half.
Okay,
And
If
if
anything
Gina
happens,
passes away,
then I
last
end up-
woman standing.
I see.
You own
And so
property.
the heirs have no claim if it's joint tenancy with rights of survivorship. Only the parties involved in the transaction, in the sale, or the ownership. If there's four of us and each of us pass, then our heirs cannot claim.
True.
Got it, got it.
True. Now these need to be set up really carefully, and you'll want your attorney to set it up, because I saw a transaction the other day where it was a husband and wife who acquired it with their sister-in-law. And the problem came up is that the deed was not really stated clearly. It said the husband and wife and the sister-in-law a 1/2 interest as joint tenants with rights of survivorship. There were too many moving parts in there that conflicted. First of all, you were naming the two people as husband and wife, so that kind of assumes a community property relationship. And they said a 1/2 interest. That 1/2 interest was confusing because we were thinking, was the grantor only giving 1/2 interest to these three people? Or was the 1/2 interest in the husband and wife, and then the other sister-in-law had 1/2 interest? So there was a lot of confusing issues.
I see.
And then they iced it off with saying as joint tenants with rights of survivorship, which if it had been joint tenants with rights of survivorship, it
would've
would have
been clean.
assumed third.
That's right.
So at this point, we have to say, we don't really know what was intended. And so we recommended that the woman contact her attorney. And they may have to go to court to let the judge tell them what they think was the intent.
Yeah, we had a situation where it was the mother-in-law, the son, his wife, and the three of them owned it. It was joint tenancy with rights of survivorship. Mother-in-law passed away. Then, of course, it was the two remaining parties, but then they got divorced. The documents were never changed. So when the ex-husband passed away, then it passed to his ex-wife.
To the wife.
Yes.
Now, there are situations where if a property is held as community property, which is another way of holding title, if you own community property, in some jurisdictions it says that you cannot sell your half. The community property means the husband and wife both have to sell. So you can't get mad at you. Well, you wouldn't, but let's say someone might get mad at their husband. You can't sell the property out from under him. You have to
You
sell
both have
it
to
as
do
a
it
whole.
as a whole.
Now, if a husband and wife own property as community property and they get divorced, the tenancy automatically, the assumption from a title standpoint is that it automatically reverts to a tenants in common, which would be a 50-50 ownership. Yeah.
Got it.
So you don't get divorced and then hope the guy dies so that you get
Yeah,
it all.
that doesn't happen that
It doesn't
way.
work that way.
So I think we've covered all the different aspects of ownership, but thank you.
Bits and pieces. It's a fascinating field, and it's really, really important in the real estate transaction to pay attention to it.
Well, I'm sure the information was very helpful to our viewers. Thank you so much.
Thank you, Liz.